so much for coming. Glad you all got in. My name's Harry Graver. I'm the president of the Buckley program, and we're just thrilled to have you guys here. None of this would be possible, by the way, without Carol Brown, who sponsored this lecture series. So we do a quick round of applause for her. If we have you all here, we'll take a few seconds to plug the Buckley program for a little bit. We were started a few years ago to contribute to intellectual diversity on campus, and we do that through a number of ways, through seminars, workshops, internship programs, sponsored academia, and most notably our speaker series. And we're thrilled tonight to have something that really kind of encapsulates what we're trying to do on campus, which is to have a conversation from different perspectives. What's important also is that you can get involved in the Buckley program really easily. Just go on the website, look at the fellow section, and press apply. And that's pretty much that simple. And we also have an essay contest, which we'd love you all to enter. The grand prize is $1,000. It's only 700 words. And it's what is a 21st century conservative? That's a few weeks from now. Also, the Buckley program is going to crawl very slowly into the 21st century. And we have a Twitter now. And if you want to ask questions tonight, you can tweet us at Buckley program. And we'll pick a few of them and ask them at the end. But I want to kind of get started as quickly as possible and introduce our moderator who kind of get everything started. Professor Elliott is a Yale man, part of the right man from what I understand. He graduated in 1970, went to Yale Law School in 1974, and been part of Yale Law faculty since 1981. He is a practitioner, member, worked in the EPA, was a senior fellow at the Administrative Conference of the United States, and really encapsulates a little bit of the Buckley idea at Yale Law, teaching a class conservative critique of the administrative state, which we're always thrilled to know that exists. But with no further ado, we'd love to get this started as soon as possible, so I could welcome our guests, Professor Elliott, Newt Gingrich, and Akhil Amar.
So thank you very much. Yeah, it's true that I was Secretary-Treasurer of the Party of the Right when I was a Yale undergraduate. I'm the only Secretary-Treasurer of the Party of the Right to ever resign in disgrace because he was unable or unwilling to memorize the names of the kings of England. So I was delighted when they asked me to be the moderator of this firing line style debate, because anyone who ever saw, how many of you ever saw Firing Line or seen it on YouTube? Or, well, a number of people. So you all know that the real star of the show is the moderator, right? William Buckley, not the other participants. So I was really excited about this until I saw the publicity material. And it had Newt Gingrich in really big print and Akhil Amar in really big print. And if you looked really in like agate type, it said, you know, moderated by E. Donald Elliott. So I actually had the privilege of knowing Bill Buckley when I was a Yale undergraduate, and I've been channeling him, and he told me clearly that he never would have stood for that kind of billing. But we have really distinguished participants tonight. Newt Gingrich is obviously a person who needs no introduction. Somebody said that once about Henry Kissinger, and he piped up and said, "But I enjoy being introduced so much." So Newt Gingrich is really a polymath. He is a distinguished and very creative historian. He's a presidential candidate. He's the author of numerous books. He's a television personality, a presidential candidate. And most distinguished, I think he's the leader of the Second Republican Revolution, the work he did to organize the Republicans in the House of Representatives, I think in retrospect appears to be an incredible accomplishment. So we're delighted to welcome Speaker Gingrich to Yale. His co-participant tonight, I will see whether they're really debaters or co-participants, is Professor Akhil Amar. Professor Amar is, I think, everyone would say, one of the leading constitutional law professors in the United States. I would say the leading constitutional law professor in the United States. He's very hard to characterize as to whether he's a liberal or a conservative. He's really developed his own approach to constitutional law. And of all the law professors that I know, I'm most confident that, 200 years from now, people are going to be reading his work and having to deal with it. So Professor Amar is a Sterling professor at Yale, one of the highest academic award that the university can provide. And I have a particular connection with Professor Amar because he broke my record for getting tenure in the quickest time at the Yale Law School. So we're delighted to have them both with us tonight. The way we're going to do this is the topic is lessons of the Constitution, and each of our participants is going to spend a few minutes talking about what he thinks the lessons of the Constitution are, and then I'll give each of them a chance to respond to some of the ideas that the other has put forward, and then we'll ask some questions. And by flip of a coin, Mr. Speaker, you have the opportunity to go first.
Well, I take it the opportunity or the requirement? I just want to find out, am I required to go first? Because I'd be certainly glad to let Professor Amar go first. But if I have the opportunity, the requirement to go first, I'm eager.
Yeah, it's like football. You can either kick or receive, as you prefer. Do you choose to go first or you choose to go second?
Parse your language. You use the word opportunity. I wanted to ensure whether or not actually it was a secret word for requirement. But I got it. I will say, first of all, Carol, thank you so much for making this possible, and I really appreciate what the Buckley organization is doing, and Bill Buckley's extraordinary achievements over a lifetime of commitment to freedom. And I did a number of firing lines with Buckley, and one of my favorite examples, because he had thought about this a long time, and he was doing television when there was no Fox, there was no Rush Limbaugh, there was no Sean Hannity. I mean, literally there was a period, I think, when the only 90 minutes of conservatism in American media was Bill Buckley. And one night we did this one debate, which was so totally one-sided in our favor. I mean, he picked several people I won't name who were, let us say, in the late stages of their career and had not had a serious thought in at least a decade. And they defended the left. And then I think he had Gene Kirkpatrick and one other person and Bill and me. And the four of us were up against these four liberals. None of the four liberals were capable at that stage, and they were all brilliant people once upon a time, but not this week. And when I got over, I said, Bill, that was really one-sided. He said, look, this is the only 90 minutes I control. We win. So this, of course, being beyond our control is not quite as obvious. I just want to make...
And for your closing statement, Mr. Speaker, no.
I just want to make two large points. And they were both struck. I spent part of the afternoon at the Peabody, mostly looking at dinosaurs, but I spent some time in the Egyptian collection, which is very interesting, and with a young professor of Egyptology. And it's actually a fitting place to start to talk about our Constitution. The Founding Fathers are essentially trying to deal with two problems which have perplexed humans for all of recorded history. They are first trying to deal with the problem, how do you establish order without having it lead to dictatorship? And they thought of themselves as engineers, and they wanted to consciously design a governmental machine so inefficient that no dictator could ever make it work. And so they divided power in 5 ways. They divided federal power between the Congress, the President, the judicial branch. They then divided power between the federal government and the state government, and they then reminded us that ultimately power resides with the people, something which they were vivid about in the Declaration of Independence. So you have to see the Constitution as an architectural design to minimize the danger of dictatorship. And that's the central principle they operated from. The second thing they had, which was central to their existence, and grew out in part of the English Civil War, Cromwell, and then the experience of the British monarchy under Hanoverian rule as the Georges took over, was this notion that you had a permanent danger of the law being used against you. And so people tend to forget the number one battle cry of the American Revolution was no taxation without representation. The number 2 battle cry was against British judges, because they saw judges as elements of the state designed to impose the king's will on unwilling American people. And they were very hostile to the idea of the judges being dictators. And so they wanted the rule of law, because they thought that only through the rule of law, 1, could you protect the weak from the strong. 2, could you give people a guide for their own behavior, because they knew there would be fair play. And 3, could you protect the person from the state, which was ultimately the thing they most worried about. So I think when I view the Constitution, I start from a premise of how do we limit the government's power, how do we protect the people, and how do we create environments in which judges don't become like British judges and decide that their elite values should be imposed upon the rest of us because they can get away with it.
Professor Amar.
First, I would like to thank the sponsors of this event. It's a great privilege to be here. Ladies and gentlemen, thanks for coming. And Mr. Speaker, welcome to Yale.
Glad to be
I think
here.
this is your first trip here, and we hope you come back again and again. So in the spirit of generating a genuinely sort of provocative dialogue, I'm going to emphasize certain themes about the lessons of the Constitution with you in mind. If I were standing alongside Nancy Pelosi, I might actually emphasize a slightly different set of themes, just to push her buttons and get her going. So America's, this is a very special time. Tomorrow is officially Constitution Day, because 226 years ago, on September 17th, 1787, proposed Constitution went public. And the world would never be the same. I'll say more about it. So this is a very special time to commemorate the Constitution. And I want to tell you a few things about the Constitution and get your reactions. Constitution is not a one-off event. It's actually an intergenerational project. Really, there are 4 main bunches of constitutional texts that together account for 98% really of the words. The first generational cluster is from the founding and the Bill of Rights era, and then again after the Civil War, the Reconstruction period, and then again in the 19-teens, the progressive era of American history, and then again in the 1960s. All the amendments basically come from those all the texts, those 4 periods, except for 2 pretty minor ones. So it's an intergenerational project, and for these purposes today, I'm going to say here are the themes. Compared to what went before, at every stage, the people who brought you the Constitution and its amendments believed in national, liberal, egalitarian government. So, the Constitution created a much stronger national government than what went before. You want inefficiency? Stick with the Articles of Confederation, and a bunch of traditionalists did, but not George Washington and Alexander Hamilton and John Marshall, who gave you a national government capable of solving genuinely national problems, interstate problems and national security problems. So, inefficient perhaps, but that can be overdone, and the Articles of Confederation overdid it. Democracy, more people got to vote on how the Constitution, on whether the Constitution was going to be adopted than they'd ever gotten to vote on anything before in human history. We, the people, indeed, and by that I mean indeed, property qualifications were lowered or abolished in 8 of the 13 states, and they were not raised anywhere. This was a remarkably democratic, egalitarian project, again, compared to the Articles of Confederation, which had no such we, the people, authorization. The Congress has a branch that's directly representative. That's not true of the Articles of Confederation. No property qualifications to be a member of the House or Senate or presidency. These are radical, egalitarian, democratic ideas. An apportioned House of Representatives that's going to be more populist, and no religious qualifications. Actually, they're prohibited. Stunning. No state constitution has this kind of openness at the time. 11 state constitutions have religious qualifications. So a remarkably liberal document. Nationalist, liberal, egalitarian, and then, because you see there was a compromise with slavery at the heart of this, the system almost failed, and in its wake, in the wake of this near-death experience, we experience a new birth of freedom, the 13th, 14th, and 15th Amendments, national, egalitarian, liberal. These amendments that emerge after the Civil War, championed by the party of Lincoln, the grand old party, the Republican Party, all end with the words, Congress shall have power, affirming racial equality and a right to vote, a phrase that appears twice in the Reconstruction Amendments. And then, we're not done, the progressive era, more right to vote now for women, redistributive, nationalist income tax, supported once again by the party of the grand old party, your party, by Teddy Roosevelt and William Howard Taft and Nelson Aldrich, grandfather of Nelson Aldrich Rockefeller, national, liberal, egalitarian, and once again in the 1960s, these great reforms, national, liberal, egalitarian, racial justice, and end of poll taxes. That is actually the essence of our Constitution, especially as amended, a Constitution that 5 times talks about the right to vote and that embody this is the founding. Now here's the question for people on your side of the aisle. Today, there are some members of your party who don't seem so enthusiastic about the right to vote. 5 Republican-appointed justices invalidated key parts of the Voting Rights Act, an iconic statute, Voting Rights Act of 1965. All the Democrats seem enthusiastic in Congress about fixing the statute, revising it, reinvigorating it. Haven't heard as much from your party. So the question, Mr. Speaker, is, because here's your moment to stand up and tell those elements of your party that your party should once again be the party of Lincoln and of Roosevelt and of national liberal egalitarianism, Teddy Roosevelt, and so what say you to this invitation, Mr. Speaker, to reclaim your party and set it right again?
Mr. Speaker, you may respond to anything you like, not necessarily the last question.
Well,
what do you think, national, egalitarian, liberal?
Look, I'll respond to 2 things that are in your, generally not, I think, incorrect interpretation. One is, all of the changes you described that you approved of, except maybe some in the 60s, were in fact done by constitutional amendment through due process, in which the people of the United States, having talked it out, made decisions, which is radically different than the elitist courts we've had since the 1950s, which seem to think you can avoid the amendment process by having super wise judges impose on the rest of the country whatever this week's random opinion is. So I don't disagree with your description of the long wave of American history, which has been visionary, inclusive, egalitarian, and sought to widen out year by year who's allowed to be considered a human being. I think that's part of what makes us such a remarkable country. But I would notice a sudden change in the 1950s in which law schools finally won, and we were told that a handful of appointed lawyers can replace an entire constitutional process, and they can decide whatever this week's decision is based on the 5th attorney getting up that morning and deciding he switched his position or her position. And so I really deeply resist the idea that what we've been through since the late 50s with the Warren Court is a sound constitutional process. And I think it's dangerous. Second, I am fascinated with the left's passion about the Voting Rights Act. I have a very simple view. I think every American citizen who is legally an American citizen should be able to vote once. And I am for any system which enables every single American who's legally an American citizen to vote once. That somehow gets translated in the idea that we should have basically no mechanism to find out who's voting because it might, quote, suppress the turnout. Now, surely there should be a way to design a model which could involve, as it does in some states, you can walk into any Walmart or any retail drugstore and for free get a voting card. Now, I'm not quite sure how that suppresses the vote, but there's this passion on the left for ensuring that we have no idea who's voting, how often they voted, or whether or not they're American citizens. And I just think that is a fundamental assault on the rights of the American people to have their own vote count.
Professor Amar?
So maybe there's common ground here, because what we really haven't seen, I don't want people to vote twice. I don't want or even 3 times for that matter. And I don't want people who aren't eligible to vote, but let's be honest. There are movements afoot in many a state to restrict voting, to restrict early voting, to restrict Sunday voting, to have all sorts of requirements that we never had before for partisan advantage. Let's be honest that that's actually happening in places like North Carolina. And long term, this is not a good political strategy, I think, actually, for the Republican Party to have the brand tarnished. And long term, it's actually not consistent with what both parties actually worked to accomplish in our lifetime. Republicans as well as Democrats supported the Voting Rights Act of '65 and its extensions. Overwhelmingly, members of your party supported those extensions, and we are not hearing, actually, from leading voices in the Republican Party critiques of, for example, what North Carolina has done, what Texas has done, what's being floated in a whole bunch of other states.
But let me directly, because I'm a little confused by part of what you said. You said these are unprecedented. No, up till very recently, you didn't vote in mid-September. Up until very recently, you didn't have every ballot mailed out as it is in Oregon. I mean, the fact is there's been experimentation over the last 20 years with trying to find a way to make it as easy as possible to maximize the opportunity to stuff the ballot box. And I would just question, I mean, I distrust power. That's why I'm a conservative. I think Acton was right. Power tends to corrupt, and absolute power corrupts absolutely. And I think that it's legitimate for the average American to want to know that their vote will not be canceled by either somebody voting multiple times or by somebody who is entitled to vote voting. And I find it, I don't sense any, there's a lot of people who want to jump up and down, vote suppression, but I haven't seen any serious effort on the left to design a new modern technique. I mean, in the middle of the world of Facebook, Twitter, Google, surely you could design an accurate voting process by which you could block people from voting more than once, and you could block people from voting who shouldn't be allowed to. And now, I don't sense anybody on the left interested in any way in having an honest election.
Just a point of clarification. I noticed that the speaker talked about citizens voting, and Professor Amar talked about people voting. And you both called for honesty and thinking about the political consequences. Isn't this really partially about whether or not those who are in the country illegally should be allowed to vote?
Well, I don't think that they should be allowed to vote, but I did see with my own eyes people standing in lines for 4 and 5 and 6 hours. And if you didn't see them, go on YouTube, because we live in a fact-based world. In the same way that we can see videos of children being gassed. We can see this with our own eyes, and there are no wounds on them, so we know that this is a chemical agent here. This happened in the last election, and I actually haven't seen evidence of massive voter fraud. And if you have some, great, but I'm actually saying, let's forget this left-right thing. Let's get together again, sure, as happened in 1965, and when this iconic law was reenacted with overwhelming majorities for both parties. Let's come up with a system, because we both, in theory, believe the same things, that people should be allowed to vote who are eligible to vote. Right. And we should make it actually easy for people who are lawful voters to vote, and you shouldn't have to spend 8 hours in a line. I don't trust government either. And if I can go to my ATM or my bank and get something in 3 minutes, or when I go to the Apple store in 3 minutes they've got everything, why can't voting be that way? Because we own this country, and the people who are running the elections, many of them are running them for partisan advantage. Let's be honest about that.
Let's move on to something else, but I'm going to give the speaker a chance to respond. I'm going to give the speaker a chance to respond.
Okay.
But I think it's time to move to some other issues.
I want to make 2 quick points. One, the iconic video you're talking about took place in Miami, where a Democratic-run registrar's office was so incompetent they couldn't get the things open. Now, it's a little much for me as a Republican to get blamed because incompetent urban Democrats in Miami couldn't get the thing done. Second.
All right,
One
time
more
out.
thing. Second. In 1965, I was an Army brat from Pennsylvania. I first encountered segregation when we moved to Georgia when I was a senior in high school in 1960. In 1965, the government of the United States had to intervene because state power was being used in a number of states to deliberately and methodically block Americans from voting. Those states today have Democratic senators who are black, they have Democratic congressmen who are black, they have Democratic mayors who are black. This is a different world, and that was a major part of the Supreme Court decision that this, I know it's shocking, this is not 1965. It's a new world with new problems.
Okay.
So now we are in favor of 5 lawyers, judges, striking down this statute. You just heard about these rule by judges. 5 judges, all appointed by one political party over the objection of judges appointed by another striking down a statute that passed by over 90% by both parties again and again in its reenactment.
All right. Well, let's pick up on the judicial review aspects of that rather than the voting rights aspects. Talk about rule by the judges for a minute. Channeling Bill Buckley, I would like to ask, what is the reason for this Confucian idolatry of the founders, Mr. Speaker? If we're talking about lessons of the Constitution, aren't there some things about the Constitution that didn't work particularly well? Lessons are also things that didn't work well. What about judicial review? Judicial review was well known at the time the Constitution was adopted, Dr. Bonham's case in England, and yet the Constitution is silent about these 5 judges. Judicial review is not mentioned one way or the other in the Constitution.
First of all, I actually agree with you that I think judges, including 5 appointed by Republicans, should be a lot more cautious. So you didn't ask me whether or not I thought it was a wise thing for them to do.
This is agreement. This is good.
Yeah. And I'd love to have 3 or 4 decisions that are otherwise, to see if you'd also agree that was unwise.
Try me.
But here's the, we probably will before the evening's over. Look, the Founding Fathers, let me go back to my original point. Founding Fathers didn't like judges and didn't trust judges. Hamilton makes quite clear that a judge who routinely runs across popular opinion can be impeached. He makes very clear that they can be stripped of their office. And he says to us, you don't have to be afraid of these judges. Jefferson says the idea of judicial review by the Supreme Court would be an oligarchy. I mean, it would be fine. It would be just a bunch of lawyers with no legitimate rights making decisions to overrule the American people. So I am very skeptical of the growth of the modern lawyer-dominated Supreme Court idolatry in which somehow we're told these 9 people stand above the rest of us. There is no judicial supremacy in the Constitution. The court is one of 3 equal branches, and Lincoln refuses, for example, to take the Dred Scott decision beyond the immediate case. Absolutely refuses to impose it. Says it's wrong, and he's not going to do it. So I think that I think the judges would be very wise to have a much more modest view of their ability to fundamentally change the American Constitution by whim.
But by your own hypothesis, isn't this a failure of the Constitution? The Founding Fathers attempted to constrain rule by the judiciary, and yet you're arguing that rule by the judiciary has come about. Isn't that a failing of the Constitution?
It's a failure of our political elite, which has been quite cheerful about hiding behind judges and having judges do things they couldn't do because they'd have been defeated. Any time the Congress and the President want to, they can in fact bring the judiciary back into line, but your political elites have refused to deal with it.
Professor Amar?
I think I agree with about 85–90% of that. I'm not such a fan of impeaching willy-nilly. You know, been there, done that. But Article 3 is 3rd out of 3, and the least amount of text is devoted to it. And Alexander Hamilton, I think, aptly describes the judiciary at the time as the least dangerous branch of government for the entire period before. And here's one of the reasons there was, I think, some skepticism of judges. In 1776, 10 of the 13 state Supreme Court justices, chief justices, in the 13 colonies, now states. In 10 of the 13 colonies, the Chief Justice sides with George III against George Washington. They are not heroes. Judges are not heroes of the American Revolution, and so there is some skepticism of them, and there's more trust in juries, actually, than in judges. And in the entire period before 1850, there's really one time that the Supreme Court invalidates an act of Congress in the name of the Constitution. It's called Marbury versus Madison. It's a technical issue about the original versus appellate jurisdiction of the court itself. So it's a law about the judiciary itself. It's one half of one sentence in the very big law, and that's all of judicial review against acts of Congress before 1850. And today, now I do think things have happened since then that do justify constitutionally a more robust judicial role than was true at the founding. We've had a whole bunch of amendments that have been passed with a contemplation of judicial review in a world descriptively of divided government. There's more running room for judges to get away with stuff because it's hard for them to be overruled. We have a partisan presidency, and that has changed. In the old days, see, George Washington was a president above party. And presidents were seen as constitutional decision makers in ways that I think are less true today. So the world has changed in ways that actually have validated and legitimated more judicial review than was true at the founding. But I'm with you that actually judges are not the, in our system of government, the first branch of government. And in fact, you were the head of the first branch of government. Article 1 is first among equals, and within that, the House of Representatives, because it is more democratic. I don't love the politics of personal attack and impeachment. I think that actually has not been good for our republic, but I think short of that, which it personalizes it too much, I think there are things that the legislature and the president could do to perhaps rebalance this. And that would begin with re-adopting the Voting Rights Act that these 5 judges struck down wrongly.
Mr. Speaker, do you want to respond to that, or should we move to something else?
No, I think that's a legitimate way to approach it, and I think is a pure example of we thought that would actually begin to tame the court. I'd even be in favor of doing precisely what you just said.
Great.
Let's talk about the fourth branch of government, the most powerful branch of government, the one that's not mentioned in the Constitution, sometimes referred to as the administrative state. Mr. Speaker, you, in your opening statement, talked about the separation of powers and it being an effective bulwark against a dictatorship. One of the reasons that James Landis, as I'm sure you both know as historians, was in favor of creating administrative agencies is he thought that the separation of powers was stupid. The only way that you could get an effective government was to create an institution which combined legislative, executive, and judicial powers in one place. And we have managed to do that without benefit of constitutional amendment by creating what is sometimes referred to as the administrative state. Doesn't the creation of the administrative state and more power flowing into the administrative state show that the framers' vision of separation of powers was wrong?
No, I think quite the opposite. Remember, the framers' vision of separation of powers was a deliberate effort to avoid dictatorship. It was not an effort, while they wanted a government more efficient than the Articles of Confederation, they would have been horrified at the modern abrogation of power to appointed clerks who have enormous power with almost no accountability. I mean, I think the Founding Fathers would all look at this and say, this is a proto-dictatorship. How can you tolerate this? And the Founding Fathers, remembering that Jefferson was more anti-centralized power than the Constitution. I mean, Jefferson and Madison write privately the resolutions of nullification in Kentucky in 1798. I mean, these are guys who really distrust centralized government. If they came back and saw our current IRS, they would just think we were insane. And they would say to us, what happened to America? How could you turn this level of power over to people over whom you have no control, who get to do whatever they want to, and whose effective power over your life is a dictatorship. I mean, if you get, if the federal government comes down on you, your relative capacity to defend yourself is almost nil. And I think that they would call for a radically smaller central government, a vast distribution of power back to the states, but they would also say to the states, don't just return it from Washington to the state capitol. Return it from the state capitol back to the people. That we've gone through a long cycle, really starting with the progressive era, where we distrust the people. We trust, quote, professionals. The professionals are going to do, quote, the right thing. And so we allocate power to the professionals who will then somehow magically always be right. Well, the Founding Fathers would all have said, this is an invitation to disaster. And just one closing note. These guys were all practical. They had dealt with the British government. They had dealt with bureaucracy. They understood the power of unnamed people who were able to block you, were able to punish you, were able to impose costs. These are not theoreticians. These are people who've been very successful and had dealt directly with power, and much of what they're doing is a direct function of the Whig critique of the British monarchy and the way the British government worked. And I think we would be well served to be dramatically more in the spirit of the Founding Fathers than the current bureaucratic state which surrounds us and I think genuinely threatens us.
Do you agree with all that, Professor Amar?
I do think that the founding world was one that had much less officialdom, much smaller federal government. There were many fewer genuine interstate problems. Smokestacks did not generate pollution that wafted into other states, creating acid rain. So in effect, one state imposing a cost, a tax, on another state that's not represented in that upwind state, as kind of taxation without representation. 90% of people lived and died in a 50-mile radius. And so there's just a lot less genuine interstate and international commerce. My kids think that milk comes from cartons. And they haven't really seen very many cows. And that's because we have refrigeration and transportation technology. You can have cows basically in California, Wisconsin, and Vermont, and the rest of us drink from them. Ours is a world with much more interstate commerce. Ours is a world where we're much more connected to the rest of the world. These things are going to empower the central government. And because you've lived in a state of kind of constant war, Cold War and hot war alternatingly, that's going to conduce to executive power. We could talk about a massive bureaucracy of the military, a vast military industrial complex that the framers knew not. America is free for most of its history because there's no standing army in peacetime for the first 150 years. And 50 years ago, General Eisenhower, President Eisenhower, actually, as he's leaving office, remarks on just what a transformation it is when you have a very different sort of... now, that's a bureaucracy that, will also get us to the moon and do other amazing things. The founders relied more on juries. They trusted juries more than judges. But juries are non-expert bodies. They can't do big science. So it's a more complicated world. I'm not going to defend every aspect of the administrative state. I will say that since my friend Steve Calabrese is here, he founded the Federalist Society way back when, here at Yale. He's written a very engaging book on how ultimately these administrative agencies need to be understood actually within the framers' tripart system of government. Fundamentally, they're executive branch agencies of a certain sort, he said. This is one version of a thing that you may have heard of. It's called the unitary executive theory. There are some aggressive versions that Calabrese does not endorse, C.E.G. John Hughes' work. But a narrow vision of the unitary executive thesis says that ultimately these administrative agencies should be headed by people picked by presidents and should ultimately be under the superintendence of a president of the United States who's trying to coordinate proper federal policy.
Now, if I hear this correctly, Speaker Gingrich is saying we really ought to return to the design that's truer to the intention of the founders. And I hear Professor Amar saying no, that we have to expect the government to change and adapt as the times change. Is that right?
And as the Constitution has changed, because remember, let's take the Bill of Rights. It limits only the federal government originally, and it begins, Congress shall make no law of a certain sort, and some people in the Tea Party says just Congress shall make no law, period. today, and it ends with the 10th Amendment. But you see, states misbehaved, and the war came, and we realized we needed a Bill of Rights against states, and the federal government was going to have to enforce that Bill of Rights against states. And so we begin with a Bill of Rights that begins, Congress shall make no law, but then Section 2 of the 13th Amendment ends with the words, Congress shall have power. Section 5 of the 14th Amendment ends with the words, Congress shall have power. Section 2 of the 15th Amendment ends with the words, Congress shall have power. The 16th Amendment is a big national redistributive engine, since you mentioned the IRS, authorized by a constitutional amendment. The 17th Amendment frees United States senators from...
Okay, let's stop there and not go through the others.
So this is a constitutional development. Oh, and women
He's
vote,
got them all
and they
by
vote
heart.
for the
We'll
nanny
stipulate.
state. So 16 plus 17 plus 19 will give you more of New Deal, Obamacare, Great Society stuff than the framers would have imagined. And it's a constitutional development.
Mr. Speaker, is that correct? Should we return to the design, or have the people through constitutional amendments?
I got sufficiently lost. You know, somewhere in the process of claiming that abolishing slavery meant I had to like having the Environmental Protection Agency decide which mud puddles in Missouri were acceptable, the jump of faith got bigger than I was able to follow intellectually. Let me give you an example that all of you live with. Because this specious argument is made, this is a complex world, it's a unified world. So I'll give you an example. How many of you have gotten money out of automatic teller machines outside the United States? Okay? So you walk up to an anonymous machine, you put in a card, the machine lights up and asks which language you like. You pick one of the ones you're really good at. You punch in a 4-number code. The machine reaches out across international boundaries, finds your bank, validates you have enough money, gives you the local currency without you having a clue what the exchange rate is. But you know you must still have money in the bank because it gave you cash. Now, it was an international system with international rules, which nonetheless delegated to you the key decision. Do you want money and how much? Now, the modern bureaucratic state would have said, we have carefully reviewed your life, and we've decided the amount you want is frankly too much. So we have decided you can have half of what you would like, because after all, you're probably not smart enough to know how much money you need this afternoon, and you shouldn't have that much money in Paris on a Friday night anyway. I mean, this is part of the difference. You can have very sophisticated systems. Again, look at Google, look at Facebook, look at Instagram. These are sophisticated structures within which people have enormous freedom. And I think we need to profoundly rethink the bureaucratic state from the ground up, applying to it the model that we want to maximize human freedom, we want to minimize the ability of bureaucrats to be arbitrary, hidden, and unaccountable, and we want to take back power in a very simple step, eliminate all internally applicable rules. Do not allow the IRS to judge you and find you guilty and fine you. They have to go to a real judge in order to take any steps. The minute these bureaucracies have to go to somebody outside their own system, you will see a dramatic diminution of their power.
Professor Amar, do you choose to comment on the constitutional significance of ATMs, or shall we move to something else?
I'm just thinking about how I misspent my money in Paris as a youth. But we won't get into that.
Let me ask you about one of the specific amendments that Professor Amar demonstrated he is committed to memory, and that would be the 17th Amendment, for those of you who are not following along in your playbook, which provides for the direct election of senators.
You guys did not bring your copies? I've got another one for you. I've got a few in here in case you need them. Yes, what we call, so ours, this is why I want to insist that the Constitution is not a product of merely one moment in time, not a magic moment 226 years ago, but it's an intergenerational project, and you have to take seriously. Maybe you think it was a mistake, so then let's amend it back. But you have to take seriously the deep lessons of, among other things, the progressive era in which William Howard Taft and Teddy Roosevelt and Nelson Aldrich all supported an income tax amendment. And they knew it was going to be a big redistributive tax. Okay, that it wasn't going to be a proportionate tax. They were opposed to a flat tax. The people who gave you the progressive income tax called themselves progressives, and so the 16th Amendment does fuel the national state, and so does the 17th, which means senators are no longer picked by state legislatures, and so they feel much more free to impose mandates on state government because they don't have to be re-elected by state government. They're going to be much more free to pursue big nationalist projects, and the 19th Amendment, which is about women voting, does lead, with the benefit of hindsight, to what we call the gender gap. Women are more likely than men to vote for what a critic would say the nanny state, someone else might say the welfare state, caring for people with dependencies, old people, young people. So 16 plus 17 plus 19, which is the progressive era, does give us a different constitution in effect than we had before. And maybe you don't like that, so then if you have to take it seriously, it should not be judges making stuff up, and it's an open conversation whether these were good things or not.
Well,
that is our constitution.
let's take Professor Amar's friendly amendment and ask about both the 16th Amendment and the 17th Amendment. Are the progressive era amendments, the direct election of senators and the income tax and their transformative effects on the federal government, are those mistakes, Mr. Speaker? Should we undo them?
I don't think they're mistakes, but let me just start with this idea of how much change has been. I mean, I commend to all of you Gordon Wood's book on the radicalism of the American Revolution.
Great book.
Yeah, and Woods makes the point that by the time you get to 1815, the America that is emerging has almost no relationship to the elite hierarchical world of George Washington and the Founding Fathers. That what's happened is commercialization, economic growth, democratization are all changing America in very profound ways. So in that sense, we as a country, we have always been evolving. Now, I want to draw a distinction between the two. I think, first of all, as a practical person, I think going back and revisiting certain amendments is an interesting academic exercise for somebody who wants to do it, but it has zero meaning in the real world. I mean, the odds against our repealing the 16th Amendment and giving up the power to tax directly are like, 100,000 to 1 against. So as among the major reform projects I'd like to undertake, this one didn't make the first cut. The second one I think is actually a good amendment for a couple reasons. And I don't think it naturally or automatically nationalizes things. I think a U.S. senator elected by popular vote from South Dakota is amazingly different from a U.S. senator elected by popular vote from California. But part of my reaction, again, is very simple. Have you ever looked at some of our state legislatures? I mean, why would you want to take power away from the American people to give it to them? I mean,
Well,
you look at the Illinois state legislature in one of its down cycles, which is normal.
Well,
why would you want them to pick a U.S. senator?
Taking your point that this is an academic exercise, maybe let's turn to something more concrete. So recently we had the former KGB officer, Putin, lecturing the United States about the importance of complying with international law. So this is an issue on which the founders are notoriously ambiguous. First of all, as a concrete, imminent issue, is the United States bound by international law?
The Founding Fathers wouldn't have been ambiguous. The Founding Fathers would have said, are you nuts? The concept of international law created by a coalition of Zimbabwe, Chad, Mauritania, I mean, give me a break. The Founding Fathers would have said, what is the sovereign frame of reference with which you're going to create any kind of genuine law? I mean, they would have had nothing but scorn for that model.
Professor
Amar? The
Amar?
United States is a sovereign nation based on freedom, and the United States should be very cautious about getting itself either involved overseas or allowing other people to try to change our culture in patterns that are beyond our control. So I think they would just laugh. Secondly, the Founding Fathers, although they debated a lot, but they're broadly stated, the most sophisticated Founding Fathers would have loved Vladimir Putin. They would have said, what a deal. I mean, here you get a trained KGB colonel, fresh from assigning people to being tortured and killed, having just killed 300,000 people in Chechnya, having invaded Ossetia without any legal basis, and he's lecturing us. Do you need any evidence of how baroque our country has gotten that we would actually pay attention to a guy like this lecturing us? Professor said this is nuts.
Professor Amar, international law and the Constitution?
Since you're now at CNN, I have an op-ed coming out tomorrow in CNN.com on Constitution Day, and here's what I say. I say, when the Constitution is adopted on September 16th, today is September 16th, 1787, so 226 years ago, there's democracy almost nowhere in the planet outside of the Americas, and there hasn't been for recorded history. A few tiny little city-states that weren't able to defend themselves militarily against their opponents, and even there, people, spoke the same language and worshiped the same gods and met face-to-face. Nothing like the United States. Okay, so we are the only democratic project really going, except on September 16th, 1787, there's, apart from us, just the Brits and the Swiss, and that's about it in the world. And then, over this amazing year, an entire continent got to vote, ordinary farmers, on how they and their posterity would be governed, and free speech. And then they shook hands afterwards and actually came together, even though they had been opposed. Republicans and Democrats, anti-federalists and federalists actually getting together after this fierce debate, and the world would never be the same. Now and so they were skeptical of the rest of the world. Why should they care about the law of princes among themselves, which is what international law is? It's not, in its deep essence, it wasn't about democracy, because the world wasn't democratic. But here's the changed circumstance that's the challenge for this generation. Today, half the world is democratic. It's democratic in the model of the United States. Written constitutions, free and fair elections in many places, respect for minority rights, and now we won. The world is becoming American in this profound sense, and so the contempt that you may have for the rest of the world, and some of the founders had a lot of suspicion of this, is this warranted in a world, and I'm not talking about Putin, who's a thug. I'm talking about India, which has 1 billion people, many religions on an American model, and Great Britain, and France, and Italy, and yes, I said France. There, I said it, okay? Even France, okay? Because it's no longer an absolutist monarchy, and you have to take seriously the other democracies of the world. And the UN isn't that today, because it seats thuggish regimes alongside democratic regimes. And the G20 is for the rich, and OPEC is for the oil nations, and the Arab League is for the Arabs. We don't have a world organization, a genuine alliance of democracies, but if we did, we should take seriously what fellow democracies have to think about.
Okay, now I've got a problem. My problem is I have 5 very interesting questions here, and I have a notation that we have to finish by 8:20. So doing my math, I would ask each of our speakers to respond in 2 minutes or less, so we get a chance to go through all of these. The first question is about the war power. And as you know, the Constitution makes the president commander-in-chief, but gives Congress the power to declare war. Isn't that a mistake, an ambiguity? And to what extent is the current war powers resolution in line with the framers' intent?
Well, look, I think the current War Powers Act is virtually irrelevant, unenforceable. I think Congress has one clear capacity, which is to either cut off funding or to pass by a veto override majority a requirement to stop doing something. I think you go back as early as Jefferson, for example, sending the Navy and the Marines to Tripoli.
Barbary.
And I mean, the Marine Corps hymn starts with, Mexico and Tripoli, just as a sign of, we've had very few declared wars, and they generally are wars of enormous scale. We've had an amazing number of skirmishes. The commander-in-chief's capacity to manage skirmishes within the legal framework set by the Congress for raising armies and maintaining navies, and within the money allocated by the Congress, in the absence of funds being cut off or a veto override majority blocking them, I think absolutely overrides the War Powers Act.
Professor Amar, do you agree, or shall we move on?
I think I agree with about 90% of that. I think I would have been a little less provocative in my characterization of the war's powerful resolution. I don't think it's so good, but you have a way with words and you don't mince them. But I don't think it's a great resolution, and it hasn't been particularly effective. Every section of it has a constitutional problem or a fatal ambiguity to it. Congress does have power to regulate the use of armed forces in all sorts of ways, and ultimately it has the hammer of a funding cutoff.
So here's another one. Was John Roberts right on Obamacare? And what's interesting about it is it suggests that one person, John Roberts, made that decision. Is the 5-4 decision upholding the Affordable Care Act correct or incorrect?
I thought he was far too clever. I mean, I have no way of, one of the virtues of a system of law should be predictability. I know of nobody who predicted that John Roberts would figure out that clever gambit. And I think cleverness on the part of Supreme, okay? Well, I've now met the first person, okay? I now met the first person.
Also Walter Dellinger, I think Akhil, a number of people predicted that.
Okay. Well, I was actually vacationing in Italy, and I apologize. I was not reading the appropriate people, but I was surprised just because by everything ostensibly we had known about Roberts, it came to me, my instinct was it was an amazingly political decision by a Chief Justice who, it's a little bit in that sense like John Marshall, in that Roberts wanted to find a way to say no while saying yes because he didn't want to get in a straight-on war with the president, but in the process I think he dramatically shrank his role, and I think it was very dubious.
But doesn't it really greatly expand the ability of the federal government to do a great many things as long as it does it through the taxing power?
The federal government currently is so capable of doing almost anything at once without this court slowing it down very much that I don't think that matters a great deal.
So you've given up?
So I do think the tax power is key, and I've emphasized it again and again from the founding, which is about creating a federal government that can tax people to fund an army and other nationalist and internationalist projects, to the 16th Amendment, which I've emphasized again and again. If you look at Slate.com, a piece that I posted 2 days after the oral argument, the day before the Supreme Court conference, read the last 2 paragraphs of that short post. I say it will be upheld on the tax power with John Roberts joining the liberals, and that's the correct approach. So some of us, and Walter Dellinger said it a day before. Actually, I heard him on the radio because we both listened carefully to what John Roberts said on the first day of oral argument. He said 3 words that actually were key. The 3 words were, or else what? If you stick around afterwards, I'll tell you what those 3 words meant. But from the beginning, he actually signaled an openness to the tax power argument, which I thought was a correct one. I would have also thought that Obamacare could be upheld as a regulation of interstate commerce, as a national security measure, as a human rights measure, and I can tell you about that later on. But bottom line,
and it will have to be,
and he was Marshallian, John Marshall-like, in a bunch of ways. I think that's a very astute analogy.
Okay, next question. How can we reconcile the outdated Second Amendment covering muskets with today's weapons? That's a question with a point of view.
I think this is one of the more fun things historically. The Second Amendment has nothing to do with target shooting. It has nothing to do with deer hunting or duck hunting. The Second Amendment is a political amendment designed by a group of people who had watched the English government take control, both in the English Civil War and in Cromwell's dictatorship, and who believed that the only reason they were not repressed totally. And if you read Paul Revere's Ride, which is a brilliant study of this event, the case is made very clearly. The British Army knew how to suppress peasants. They had suppressed peasants in England, they'd suppressed peasants in Scotland, in Wales, in Ireland, and they marched out to Concord and to Lexington to do what they knew how to do. And they ran into self-organized militia who were armed and who actually went to war over their weapons. In the Second Amendment opening round is the shot heard around the world. So I happen to believe that there's a lot of truth to that, and that in fact an armed populace makes it a lot less likely to get to a dictatorship, and that's a risk I'm willing to run.
Akhil?
Remember that the Constitution isn't just a product of the founding. We have to think not just about the Second Amendment, which emerges in the founding era, but the 14th Amendment. And the 14th Amendment actually had a slightly different focus. It wasn't about state militias checking a federal standing army. That's what the Second Amendment's about. Lexington conquered Bunker's Hill. That's the American Revolution. The 14th Amendment is the product of the Civil War, and the Army are the good guys. But they believed in the Second Amendment. They believed individuals had to have a right to have a gun in the home for self-protection, and in particular, blacks had to have guns in homes for self-protection because you couldn't count on the local constabulary to protect you when the Klan came calling. So here is yet another example. I believe there is an individual right to have a gun in the home for self-protection. It's deeply rooted in American history and tradition, but also in the 14th Amendment. It's subject to reasonable regulation, as are many other rights in the Constitution. But here's where liberals and conservatives can actually, again, find common ground on stuff. But let's remember, again, the Constitution isn't just about the founding. The 14th Amendment is hugely relevant here. So the key case is not merely the Heller case about federal power in D.C., but also a case called City of Chicago versus McDonald, a case affirming a right to have a gun in one's home for self-protection against local laws, Chicago ordinances, or state laws that might try to accomplish.
Mr. Speaker, any comments on that? No. All right, let's move on. Does the level of power given to the National Security Agency in the name of, quote, national security, I'm not sure exactly why that's in quotes, but of, quote, national security worry you? Is this something we should limit?
Oh, I think it's an absurdity.
Which, the question or the national security?
No, I think first of all, I believe we need a law which ruthlessly distinguishes counterterrorism from all other legal activities. Because I think you can make a case, the Chechens in Boston, that you do have an interest in a very high level of intelligence about people who might try to bring in a nuclear weapon or a chemical weapon or what have you. But the idea that you currently have an agency which is randomly scooping up anything it finds, and which, in some cases, clearly is turning that over to non-national security agencies, I think is an absolute and direct threat to our freedom. And the idea that over time that will mutate into the government's ability to coerce people and intimidate people is, I think it's 100% guaranteed. And so I would be very cautious. I mean, I think you have to gather a lot of information to stop terrorism. You have to gather a lot of information to stop an enemy threat. I'm for that. But I would wall that off, and I would make it a felony with very long penalties for anybody to release any of that information to any law enforcement agency of any kind in this country, or to release it to the public in any way. I think this is a very big problem.
Professor Amar?
I'd want to study that one more before I take a position.
Okay. The next question has to do with constitutional amendments, and Professor Amar has stressed the process by which the Constitution has been amended over time. The question is, are there any constitutional amendments that you think either we should support or that you find dangerous? And let me just add to that, Mark Levin has recently published a book called The Liberty Amendments, in which he's proposed a series of constitutional amendments to try to restore the structure of government to that of the founding. Are there any there have been a lot of debate about balanced budget amendments over the years. Are there any constitutional amendments that you think we should consider, or any that you consider particularly dangerous?
Well, most of my career I supported a balanced budget amendment. I think given the propensity of politicians to spend everything they can get away with, I think there is some virtue to some kind of prohibition or some kind of limitation on debt.
Kind of restraint.
And I think what Mark's trying to do in his book is start a conversation, and he's very good at doing that. The only thing I would say is that I can't imagine a constitutional convention in this political culture which wouldn't be unbelievably dangerous. I mean, I would not want to see the states call some kind of constitutional convention. And I think any conservative who thinks that they would somehow magically win the vote to elect delegates in a wide number of states completely misunderstand the nature of political power in this country.
Of course, his point on that is that the convention is solely to propose amendments, which then have to still be ratified by 3/4 of the states. So
I would just suggest he ought to think about who is going to be proposing and who's going to get elected from these states, and I think it would be a circus.
I'll pass that on to him. Professor Amar, constitutional amendments?
Three prescriptive and normative rules for which amendments will be added and should be added. First, states are going to need to road test ideas first. So states have balanced budget amendments. One can say the federal government's different because it needs to fight wars and combat depressions, but that would be the conversation. Almost everything in the U.S. Constitution builds on state antecedents. Having a written constitution, 3 branches of government, judicial review, bicameralism, a separate Bill of Rights, putting the Constitution to a vote, getting rid of slavery, letting women vote. So states road test ideas first. That's a Brandeisian idea. Second, both parties, as a practical matter, are going to need to be on board because you can't get 2/3, 2/3, and 3/4. 2/3 of the House, 2/3 of the Senate, 3/4 of the states, unless both parties are on board. Third, the amendments thus far have basically added to liberty and equality and not taken away from liberty and equality, with the possible ill-fated exception of prohibition. So now, what does that mean? No flag-burning amendment, because that restricts the First Amendment and freedom. No anti-gay marriage amendment or anti-gays in the military amendment. But direct election of the president is possible because we pick governors by direct election. States do it first. Allowing a naturalized citizen who's been in America for 30, 40 years to run for president, well, they run for governor. Arnold Schwarzenegger, Jennifer Granholm, and indeed Orrin Hatch proposed such an amendment, a Republican, and he actually got Democratic support for that. So again, the 3 principles, and I've given you some applications. Both parties have to be in favor of it. It should add to liberty and equality, not to detract from it, and states should road test these ideas first.
What about direct election of the president, Mr. Speaker?
I don't see any great advantage to it.
Pardon?
I just don't see any great advantage to it. Look, I think we have so many things.
Well, the advantage to it is then everybody's vote would count. Many people feel when they're
and count equally. One person, one vote equally everywhere, no matter where you are. That's I don't think it's that hugely important, but that's the principle.
Yeah, the argument is that people who are in a state where it's overwhelmingly going to vote one way or the other are demoralized by the notion that their vote doesn't count, and we pick our national leaders based on a few swing voters in a few swing states. You don't understand the political realities. Better not.
I understand the theory you just outlined. I mean, one of my biases goes back to something you've said. I think it is helpful to strengthen the states. I think it's helpful for the states to have meaning. So I think it's helpful for candidates to think, will I campaign in California or not? Will I try? And again, I mean, if somebody says to you in California, gee, I'm really demoralized because I probably don't have any vote for president, and then we also have a Senate race, we have a congressional race, we have state legislative races, we have local county races, but I feel so demoralized I'm not going to go vote. I am not exactly overwhelmed with their sense of patriotism.
But wouldn't you be more likely
to go to California?
Wouldn't you be more likely as a presidential candidate to go to California if the millions and millions of people in California, if their votes counted in the national totals on the Republican side?
The question is, and this is purely a judgment, do you think that it is useful to have one more step to make us a purely national country and to eliminate the meaning of states, or do you think there is some virtue to having the states actually count as states? I think we are much safer in freedom in the long run if we rebalance away from Washington and have relatively more strength in the states and relatively less of this imposed nationalism that washes across the whole country.
Let's let that be the last word and thank our participants for a wonderful discussion.
Thank you. Great fun. It was good to be with you.
Let's do it again.
Thank you. That was fun.
Wonderful job.
Oh, very good.
Wonderful job.
Thank you. Thank you. Thank you very much.
Phil, great job.
Sounds great. Thank you, Kyle.